We have judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Matter of David B. Matter of Richard S. Ms. D'Elia, good afternoon.
Thank you. Madam, I've been allotted 25 minutes for argument. I'd like to reserve 5 for rebuttal, please.
5 of your 25?
5 of my 25, yes.
Certainly.
May it please the Court, my name is Leslie D'Elia. I'm appearing on behalf of Sidney Hirschfeld, Director of the Mental Hygiene Legal Service, 2nd Judicial Department, on behalf of appellants David B. and Richard S. Your Honor, these appeals, which this Court has taken up as of right, raise a single constitutional question, that is, whether it violates due process to retain insanity equities pursuant to CPL 33020 in a non-secure psychiatric center without a two-pronged finding of dangerousness and mental illness. Appellants contend that it is such a violation, and respondents appear to have conceded that argument. But their concession is illusory. The substance of their argument is that if you prove the mental illness, then you've proved the dangerousness. So their concession collapses the two standards back into one.
What is your definition of dangerousness for this purpose?
For the purpose of a non-secure facility, Your Honor, I think the best way to understand it is to look at the context of the statutory scheme of 33020 and to distinguish secure facilities from non-secure facilities. And if we can understand what the purpose of a secure facility is, then we know what dangerous mental disorder for a secure facility means. And then we can, after that, we can look at the standard for non-secure facility. Now, a secure facility is clearly defined in both the statute and the Commissioner's regulations. If you look at the definition section of 33021C, it defines a secure facility as having two purposes. One is to prevent escape, and the second is to provide that extra measure of security for people who are acting out violently. Now, in order to prevent escape, it's actually architecturally different from a non-secure facility. It has a double razor wire fence around the outside. There are double sets of locked doors. There are metal detectors. There's fenced-in yards. All of those things go to preventing escape. The second function of a non-secure facility addresses patients who are acting out violently. And to that end,
a secure facility.
I'm sorry, secure.
That's
and to that end, there's specially trained staff who are specially trained to restrain patients when they're violent. There are separate units for people who are even more violent than the general population of the secure facility, where they can be put separately. That having been said, it seems that dangerous mental disorder would require someone to need that facility.
Is dangerousness then only equated with violence toward others? Is that the only way a person can be dangerous?
That's not our argument at all, Your Honor. All I'm saying is that that's the type of dangerousness that would warrant a finding of dangerous mental disorder and placement in a secure facility.
Well, there's a statutory definition. It says physical danger to themselves or other. The statutory definition of dangerous mental disorder is contained in the statute. It says danger to the committed person or others, physical danger.
Yes, Your Honor, and the term dangerous
now,
mental disorder...
Is your suggestion as to what we should look at something more than the statutory definition?
Well, what I'm saying, Your Honor, is that the statutory definition of dangerous mental disorder refers to that group of violent patients and escape risks that I just spoke to. But for a non-secure facility, there's a different standard, and that standard is brought into 33020 through subsection 1D, which defines the word mentally ill.
Right.
And that bumps you into the civil standard, and the civil standard has existed for a very long time.
Can I ask you this, please? When let's talk about track 2 people. We understand that we're not dealing here with a standard that on the face of the statute involves dangerousness to oneself or others, but we're talking about mental illness. And I want to ask you regarding how you could interpret the state's concession that dangerousness is an element of that definition of mental illness. Can I ask you first, when did the state first make that concession that dangerousness is within the purview of the United States Supreme Court cases that require both mental illness and dangerousness in order to satisfy due process minimal track 2 type retention?
Well, they're conceding it here in this
They're
court.
conceding here now, but below?
They did concede it to some extent at the appellate division.
What about the trial level, though? They
Also, no, they didn't concede it at the trial level.
So here's my
Your Honor.
question to you. My question is whether the right resolution to this, and I'm not suggesting that it is, I'm just probing it, would be a remand to the trial level court to determine whether dangerousness, a milder level of dangerousness, milder than track 1, exists and can be demonstrated so as to justify retention under a track 2 type custodial restraint.
Your Honor, that's exactly what we're asking for, certainly in David B.
Right.
And then it gets a little more complicated in Richard S. because we also raised the issue of mental illness. So if the court were to find that he didn't have a mental illness, you couldn't even remand it. You'd have to release him because even prong 1 wouldn't have been met. But on the dangerousness issue, yes, if we could remand it to the court below, give the court some guidance that there's 2 types of dangerousness, that dangerousness for a non-secure facility means real and present threat of substantial physical harm. And we're not saying that that means that there has to be an overt recent act. That was the commissioner's argument.
So for your part, because
that.
one of the concerns that I have is setting forth criteria for dangerousness in a manner that resembles legislation, considering that the statute does not define dangerousness. And when you said give the court below some guidance, we would have to then formulate our own notions of dangerousness without any help from a statute. Is that your position?
No, Your Honor, it's not. If I may, I do disagree with you there because the standard for retention in a non-secure facility for dangerousness exists. It exists in Harry M. It exists in Boggs. It exists.
But it's all case law and not statute.
Yes, Your Honor, but neither of the respondents is contesting that is to be read into the statute.
Well, the distinction between a track 1 and track 2 is the degree of dangerousness. Is that what your contention is here?
I'm saying, Your Honor, that the
Serious dangerousness is track 1 and mild dangerous is track 2?
Well, I don't know if, I don't know if it's a continuum more than that they're actually qualitatively different things, but they're 2 different things, and I suppose you could look at it and say one is more serious than the other, and he needs to be in a secure facility, and the other really requires, if the term seems to require an element of foreseeability that the person would do something dangerous if he was released from the facility into the community.
Can you elaborate on what types of factors the court would look at under harm to oneself? What do you,
Well, okay,
would there be any situation where harm to oneself would fall under?
certainly, Your Honor, and that's all, it's not something I would have to define. The lower courts have already defined it, and so have the intermediate appellate courts. In the Boggs case, certainly in Edward L. and Carl C., that danger to self is certainly an element of it. And then there's also the second part, which is the foreseeability that this person would do something dangerous if he were outside to other people. So it's both. But it's
Well, see, that's what I'm trying to clarify. Are you saying there has to be proof of danger to others in order to justify non-secure retention?
No, well, that or danger to oneself. You don't need to prove both.
Or, because you just said and. You
You
just said there had to be foreseeability of danger to others.
on the danger to others prong, but if it was dangerousness to self, then that's enough.
When we used to do retention hearings, it would be very non-secure retention hearings.
Right.
it would be very common for a psychiatrist who's treating the individual to come in and say, if he were to leave the institution, it's quite probable that he or she wouldn't take their medication, and that within a very short period of time they begin to decompensate, they begin to again experience schizophrenic delusional behavior. They'd stop caring for their body functions. Some might even stop eating. They wouldn't wash. They wouldn't care for themselves physically in any way, shape, or form, and that it's my professional judgment that within a very short period of time that their conduct would become harmful to themselves. They wouldn't meet their own needs, and they would not appreciate the fact that their conduct was harmful to them because they would not appreciate the fact that they were mentally ill. Is that what that?
Oh, absolutely.
That testimony would do it for you in terms of a non-secure retention?
Absolutely. We're not suggesting that because somebody's been temporarily stabilized in a hospital, that means that it isn't foreseeable that he's going to go out and become dangerous to himself and or to others again.
Delia, could you define precisely for us what the shooting is about? Where is the area of greatest contention? You say the state agrees, your adversaries agree.
They seem to agree in the sense that they pay lip service to saying you have to have two prongs. You have to have dangerousness and mental illness.
Okay, where are they disputing you?
They're disputing us because then in the next breath they're saying, and you can prove the dangerous prong by proving the continuation of the mental illness. And clearly that's just not enough. That's not what the Supreme Court has said. There's a formula.
They're saying if a person fits within the statutory definition of mental illness in the mental hygiene law, that includes the element of dangerousness.
Yes, Your Honor, that's what I'm saying.
Isn't that what they're saying also?
I think the problem is in the use of, there's a, 33020 uses the word mentally ill as a term of art, and I think it gets to be very confusing. I think what they're saying is once you prove someone has a mental illness and that the mental illness is still there, that ipso facto, you can also imply that he's dangerous. And I'm saying no, that the doctor has to testify that there's a mental illness and that mental illness
can we agree on
I
this?
just want to hear the end.
Yeah, I'm sorry.
dangerous to himself or to
So
others.
the word dangerous has to be used in the opinion of the expert. Is that what's key here?
I don't think he has to use the word dangerousness, Your Honor. He has to show that there's something unsafe and it's foreseeable that it's unsafe. Maybe it's that the person needs medication, that we know he's not going to take the medication, and that he's going to go out and he's going to either hurt himself or hurt somebody else again. And that right now, as this court was very aware of in George L., just because he's temporarily stabilized just doesn't do the trick.
Can we agree?
But you had, in these two cases, there were no findings. You have one judge in David B. saying dangerousness isn't an issue at all. And in Richard S., you have them move this knee-jerk reaction from he's not dangerous mental disorder for secure to he has a mental illness, therefore he needs to be in a non-secure facility. And there's a beat missing. And the beat that's missing...
Well, is the confusion in part derived from the definition in D of mental illness to include judgment so impaired that he's unable to understand the need for care and treatment? Isn't that the kind, I understood from listening to your exchange with Judge Wesley, that comprehended the kind of dangerousness you have in mind.
Some people might not recognize a need for care and treatment, but it still doesn't mean that they're going to go out and harm themselves or harm anybody else.
Well, but they wouldn't take their medication, they wouldn't, which could lead, I understood that was exactly your exchange with Judge Wesley.
Well, he went a little bit further in the question, if I might, Your Honor, because he went to the next step, which was, and they won't eat, and they won't take care of their bodily functions. So what I'm saying is if mental illness includes an inability to recognize the illness, and certainly 1.0320 does say that.
It's one thing to hear voices, it's another thing to hear voices and stop eating, or to live in a fantasy world whereby you don't understand to care for yourself.
And that's why your question went a little bit further than your question, and I agreed with what you said, because there was still that last beat. The person is going to do something, it's foreseeable, he's going to do something to hurt himself or neglect himself or hurt somebody else.
You're not talking about cutting someone's wrists, you're talking about just taking care of what has to be taken care of to live on this earth without surviving in the context of eating and washing and...
The appellate division, second department, has certainly said that already.
Well, I
So
understand now
don't contest
the
that.
area of contention as to the non-secure facility. Is it different as to the secure? What is the area of contention between
Well-
you and your adversaries with respect to secure facility?
That really wasn't part of this appeal, so I don't think we really have that issue. Certainly in David B., there wasn't even an application for secure care. And in Richard S., there was a finding very clearly that he didn't belong in a secure facility, and they transferred him to a non-secure. And as a matter of fact, in the briefs, the commissioner concedes that they're not appealing the question of DMD.
Okay.
So as a matter of fact, even if this court were to remand the Richard S. matter back down to the lower courts, it wouldn't be on the question of dangerous mental disorder. That's resolved already. The court found he didn't have it, and that's not on appeal. It would only be on the question of whether or not he has enough dangerousness, if you want to use the word dangerousness, to keep him in a non-secure facility.
Can you state again what it is you want us to do in each case?
Sure. In David B., we're asking the court to remand the case and direct the court below that dangerousness is an issue in a non-secure retention, and that he has to make a finding as to that question.
Can you stop just for a second, because I don't want to interrupt your answer ultimately to it. But that means, what you mean by that is that when David B.'s trial went on, all the prosecutor focused on was that he was mentally ill, not the implications of his mental illness vis-a-vis taking care of himself.
Well, I'm speaking more to what the judge said was relevant, not so much what the district attorney put in, but what the judge said was relevant. Now, it's clear the judge never considered any issue of dangerousness, or if he did, that he didn't really understand the parameters of what he was looking at.
And then as to Richard S., what do you
And then
want?
as to Richard S., on the dangerous, if the court remands it, that it only remanded as to the issue of non-secure retention.
As
not
to what?
secure-
Only remand as to what?
As to retention in a non-secure facility, not on the question of retention in a secure facility. And lastly, that if the court finds that there's no mental illness here, that then you can't have a remand because you haven't even met prong one.
It seems to
And
me
as
that we're almost in a semantic dispute here over whether a physician's, a medical definition of mental illness is what they were doing, and that was the nature of the testimony in these cases, as against the legal definition of mental illness, which includes an element of dangerousness. Is that really what this is all about? You're really saying, seems to me you're saying that mental illness for purposes of the CPL incorporates the case law interpreting mental illness as defined by the mental hygiene law to include some element of dangerousness.
That's the substance of the dangerousness argument, Your Honor. But on the question that we also raised of whether or not there was a mental illness present, what we were saying is if the only finding that the court makes is that there's a mental illness and it's in remission, then you don't meet the standard of 1.0320, which requires the illness to be manifested in some way, and certainly it violates it creates an irrebuttable presumption that once you're mentally ill, you'll always be mentally ill, and that's a violation of due process, and we cited two cases.
Not only that, mentally ill, but dangerous as a result of that.
Well,
I mean, isn't it true that in Richard S.'s case that he was regularly possessing pornographic materials and his deviant, the dangerous aspect of his mental illness surrounded deviancy or sexual deviancy? He killed homosexuals with whom he had love affairs, and not one but 3 times. And the judge in this case said, look, he's in remission, but he still had these instances where he continues to possess these materials, which his treatment team say bring on episodic situations. Is that a mischaracterization?
I think it is,
You
Your Honor.
can tell me that. That's fair enough.
I think it is. I think that the court made a very clear finding that this person had a mental illness and it was in remission.
Okay.
The court didn't really put any relevance to the pornographic material. In fact, if it had, I think the court would have gone along with the district attorney's argument, and they would have put him in a secure facility. So obviously, for the question of whether or not he was dangerous for a non-secure facility, it had no weight. And with respect to the mental illness, it's very hard to keep the two issues separate.
Right.
But if you really only look at the mental illness prong, that question, the question is there an illness now? Is it manifested in any way? And if not, are we creating an irrebuttable presumption that if you were mentally ill 20 years ago, you're always going to be mentally ill? It's always going to be in remission.
There's just a procedural question I want to ask you. There are 2 retention orders here. When will they expire? When are the next retention hearings scheduled for?
You tried meeting one for David B. and one for
Yes.
Richard S. They're coming very close to expiration at this point, Your Honor. I don't have the specific
so if
date.
Maybe you could
if we
leave those
remand-
dates with the clerk.
But certainly, yes.
If we remand, will those subsequent hearings conflict now with the new retention hearings that are occurring? I'm trying to determine whether
Well,
this ought to be a prospective direction from our court as opposed to a remand.
Maybe you could answer
think
on
that-
rebuttal.
Thank you, Your
I
Honor.
have another question, though, I'd like to ask you. Excuse me, madam, before you sit down. I have a question. I want to see what is ruled out of the case. You are, as I understand it, not arguing that the statute is unconstitutional in that it cannot live with Fucha and Jones, and that therefore the patients must be discharged outright.
Quite to the contrary.
You're not
Your
arguing
Honor.
that.
I'm saying that we
Fine.
can work with this
You want to
statute.
remand
It-
for consideration of the issues that you've described here?
Yes, Your Honor.
Okay.
So there is not a constitutional question.
We can preserve the constitutionality of the statute and work with it as long as we read it
Okay.
within...
We have agreement that there is not a constitutional objection here to the statute.
Not to the statute, no, Your Honor.
Okay.
Thank you. Ms. Mearson?
Good afternoon.
Hello.
I am here on behalf of both Richard S. and David B. My colleagues are here, Mr. Kleinbart for David B. from Manhattan, and Ms. Aldea for Richard S.
Are you here to defend the constitutionality of the statute?
I don't think that's an issue. I think there's absolutely no constitutional issue in this case.
Do you have a disagreement with them at all? It's not really evident yet in my mind, because it sounds to me like you can see there are two standards of dangerousness, one for track 1 and one for track 2. The track 2 is essentially the civil standard applied for civil commitments under the mental hygiene law, and something more serious has got to be for track 1. Is that essentially your point?
Well, let me just correct one thing. I think you're using track 1 and track 2 incorrectly. Track 2 is for all defendants who are acquitted of a crime by reason of insanity who were originally found to be have a dangerous mental disorder, and then they get put into the system, and eventually some of them go from a secure to a non-secure, as has David B. and now has Richard S. They are still track 2 defendants, even though they are still in non-secure facilities. What we're talking about is the difference between track 2 defendants. You can have a track 2 defendant who's in a dangerous, who has a dangerous mental disorder, who's in a secure facility, and you can have a track 2 defendant who is in a non. Are you referring?
I'm okay. You've clarified it.
Oh, you're referring to the
We're-
track 2 defendants in 2 different facilities, right?
Clear.
Well, what I want to say about that is that we don't disagree on a whole lot with the appellants, in principle. What we disagree about, and what they're really arguing to you right now, is they don't like the way the lower courts have weighed out the evidence. What they're saying to you is, if you're retaining these defendants, then they have to be retained without a finding of dangerousness, because if you read the opinions, you don't find it in there. And while I admit you don't find it in there, you can't read the opinions in a vacuum, because they don't exist in a vacuum. They have to be read in the context of what happened in the lower courts, what the evidence was before the lower courts, what the discussions were among the parties, and what the question was on the table in the lower courts. The question on the table in the lower courts was this: both defendants committed horrible, brutal acts while they were outside a structured hospital setting. They have since been confined. That mental illness, which contains the seed of violence in both of these defendants, has been controlled because they have been in the hospital. question before the lower courts is, what is the likelihood that either one of these defendants is going to commit the same kind of act if you remove them from the amount of structure that they are now in? In Richard S.'s case, we argued below, and I still believe that he might have a dangerous mental disorder. He is so dangerous that he may not be safe in a non-secure facility. However, we lost in the lower court. We believe that those are affirmed findings of fact. There was no basis for this court's jurisdiction, and we believe that the appellants are stuck on the other side with what they found in Richard S., which was that he has a mental illness. That mental illness makes him violent when it is active. It is not so violent that the violence that is inherent in his mental illness cannot be controlled in a less secure setting. Because what the courts below have to do, pursuant to public policy and the Constitution, is they have to weigh two things. They have to weigh individual liberty and the deprivation of individual liberty against public safety. And that's what both courts were doing below. They were weighing it out. And what they both decided was that the condition, the medical evidence, the preponderance of the medical evidence, and the facts in both cases were such that the mental illness continues, the dangerousness is still possible, because neither defendant's condition has been resolved adequately or controlled adequately to allow a release that would be safe to the public. So in answer to your question, Judge Levine, the nature of the danger is the same. We're always concerned with the same thing. What will this person do if you release them to the next level of freedom?
Well, let me ask you this. As I understand, in the Richard B. case, whatever his name is.
Well, one is Richard S., one is
B.
David B.
David B. Somebody wanted to ask the psychiatrist, is this man dangerous? If this man is released, would he be dangerous?
Which
and
case?
Somebody objected to that.
David, yes.
David. And somebody objected to that. That doesn't sound consistent with what you've just told me.
What happened in that case, as unfortunate as it was very minor. One of his doctors was on the stand, and they said to him, Dr. Wiedenbecker, do you know of any violent incidents since 1995? What they were referring to was, do you know of anything that David B. did violently while he was in the hospital? Did he have bad behavior since 1995? And the district attorney objected at the time. And then there was a whole discussion about what was necessary and what wasn't. And at what point the judge said, you know, I've given you total latitude with your cross-examination of the Office of Mental Health's doctor, Dr. Mausner. And if you read the entire thing, other than that unfortunate exchange, which we acknowledge on reconsideration probably, he should have let him go forward and answer the question, because in fact there were some incidents and it wouldn't have hurt them. While that was a very small and minor exchange, if you read the transcript as a whole and if you look at what was on the table, they were all talking about the same thing in David B.
See, I understood that your position was, until you made the concession here at the appellate division, that the precise finding of dangerousness was not necessary for a trial judge to conclude that, but that it is included ipso facto within the definition of mental illness. Now it seems to me as though what you're saying and what the other side is saying is practically the same thing. You're a hairbreadth away, right?
We're a hairbreadth away.
So just to help us lead everyone out of this morass appropriately, what is wrong with a remand in which the trial level court can, based on criteria that we find and perhaps can forge out through your obvious acquiescence here, make determinations as to whether or not a person, without using magic words or semantics like dangerous or maybe using them, is such that we can be reasonably secure that this would not be repeated. You want to call that dangerousness, you don't want to call it something else. We all know basically what we're talking about. So can we formulate an appropriate protocol for remand, in your view, under standards that you would now articulate? Could you do that for us?
Yes. First I'd say that remand is okay.
Fine. So almost an agreement on that.
Well,
okay,
my first choice is affirmance.
Right, okay.
I'd like to make
your
a pitch for
fallback position is remand. And tell us your version of the criteria that we should use in one case and then in the next in order to have retention or something else.
okay, if you remand, we would want the guideline to say that while you need the same kind of showing that you need in civil cases or in secure facility dangerous mental disorder cases, but what we would ask is that you make clear that sometimes that danger is not going to be proven by any overt acts while in the facility. That you can, what my adversary has been saying all along in the Second Department and now here is, they behaved. And if they behaved, how can you hold them? And you've said this before in George L., and I think we would like you to say it again for the purpose of non-secure facilities, particularly because when you're talking about releasing someone from a non-secure facility, you're talking about releasing them to the community. We would like the courts below to consider the public safety, which they do and which they have clearly done here. And we would just want a guideline that says that danger can sometimes be proved by a showing that the medical evidence is such that the mental illness that is presumed to continue is not over, it's not improved, it's not resolved sufficiently. We would have to, in a way, we would have to come forward, it's our burden of proof to show that that presumption has not yet been rebutted.
And that embraces the element of dangerousness.
Right, because exactly. You would embrace the element of danger because what you would be doing would be to come forward with positive proof. And I can give you the example of Richard S. He always behaved. He behaved the minute he walked in 1978. So if your criteria is going to be that he hasn't acted out or that his mental illness is in remission, then that's not going to do it. He could be sitting in a corner, not participating in therapy. Does that make him any less dangerous?
So you're saying that in setting criteria for dangerousness, that there should be a number of factors that go beyond mere overt acts. There can be etiology, there can be classic symptoms of recurrence based on other instances, there can be the type of ailment that does not lend itself to a ready, quick resolution, the predictability based on other case studies. All these factors should be taken into account, you say.
But bottom line, you'd have to have a doctor, essentially, you'd have to have a doctor say that if you let him out,
It's going to decomp.
Right, or for instance...
And he's out of a structured environment and off his medication, he will there's a likelihood that he will recidivate.
Although sometimes patients like Richard S. don't have medication. And sometimes patients have conditions that don't lend itself to therapy. Or they have therapy, but the doctors can say, I don't think this therapy worked, because there have been psychological tests which show something else is going on in subconscious, things like that.
Does your answer apply to both cases equally?
Yes, it would apply to every defendant.
Thank you, Ms. Mearson. Mr. Kleinbart? Mr. Kleinbart, we seem to have ironed out a lot. You're not going to reintroduce bumps, are you?
Well, well, perhaps. I suppose the court will have to be the judge of that. Well, as I understood from the court's comments to Ms. Aldea, it's now recognized that there's no constitutional question here. So it would be our position, frankly, the court, there's no longer a substantial constitutional question, and since the court denied leave, the leave application as unnecessary, it would appear then there is no jurisdiction and the appeal would have to be dismissed.
Well,
unless the
could that be because there had been a change in position by the state and by you?
Well, that was not.
You were before the appellate division?
Not quite. Our position.
You couldn't deprive us of jurisdiction by making concessions, could you?
Well, our position, Your Honor, at least our position, I know this is not true for the Attorney General, but our position has been the same all along, frankly. I know there's been a lot of talk now about this objection that was made by my colleague in the trial court about proving prior bad acts as dangerousness. I would submit that that objection was not an objection suggesting that there was no obligation to prove what I call constitutional dangerousness. The concern the assistant had was that what was being confused was dangerousness as defined under dangerous mental disorder, CPL 33021C sub 2, and dangerousness as I think the court has begun to recognize as it is subsumed in CPL section 33021D under the definition of mental illness. And I would submit that it is simply wrong to suggest that the trial court, because of something the assistant district attorney said, did not consider dangerousness. If I may quote from the assistant district attorney's argument in the court below, which is on page 311 in the appendix prepared by the Attorney General, this is not an individual who should be released into the community. He has a distorted view, attending paranoid ideation about the crime, about the hospital, about life in general, and then to release him and have him not even recognize that mental illness is just fraught with danger, both for himself and the community. So, contrary to what seems to have been the position that my adversary has taken, I would submit that dangerousness was indeed considered by the trial court, and that's precisely what the argument the Assistant District Attorney made.
But David B. got put into a non-secure.
That's absolutely right. That's absolutely right, because that suggests, as the assistant commendably recognized, that there is some element of dangerousness that has to be shown, what I call constitutional dangerousness. And I think the court has recognized that there is a difference between constitutional dangerousness for mentally ill individuals and statutory dangerousness for 33020 patients. That's the difference between dangerous mental disorder and mentally ill. There has to be a difference.
That's the difference between secure and non-secure.
I'm not sure that I would necessarily define it based on where you put them, the type of dangerousness. In our brief, we posited the notion that someone could be a passive danger, as a danger to himself, and that is the kind of dangerousness that at least I perceive.
Well, in light of the court's ultimate determination in answering, you pressed for secure facility.
Not in David B. David B. was never a secure facility.
No, you're correct. I apologize.
So our position all along has been non-secure.
So,
with respect to
given
David
that, then I take it your view is that really there's not a need for a remand. The judge was thinking about the right things. He or she, I don't know which judge it was examining the existence of a medical condition and then correlating that medical condition to a series of medical evaluations and with an overlay of a legal standard of mental illness which incorporates a function of not appreciation of one's illness and the ramifications of the failure to appreciate that illness.
Precisely, and that subsumes what constitutional dangerousness, because to conclude otherwise means that CPL 33021D is unconstitutional on its face.
Constitutional dangerousness is that's the what the courts of New York have incorporated into the definition of mental illness for civil commitments. That's constitutional dangerousness for you, is that right? Am I correct about that?
To the extent that it includes the danger to oneself in the way we have discussed in our brief, yes, I would agree with that.
Okay, now just one other question then. You're saying the statutory dangerousness for dangerous mental disorder is of a more serious nature than what is necessary for retention in a non-secure facility under the definition of mental illness in the CPL?
It can, yes. I'm not suggesting the reverse. In other words, you can't have that kind of dangerousness and still retain someone in a secure facility. In a non-secure facility, obviously that's going to depend on the kind of application that was made. But
conceivably, there are people who can be retained in a non-secure who by statute cannot be placed and retained in a secure.
That's precisely, and that's the statute gives the.
But that's statutory and not constitutional. That is statutory and not constitutional.
That is statutory, right.
That's a matter of statute and not.
Right. There's a floor that the Constitution requires that may or may not be.
You can see that the judge, at least in David B., did not very clearly articulate what you think he did.
Well, he said.
He said, as long as it's mental illness, that's the end of the ballgame.
That's not, no. With all due respect, Your Honor, what he said was, this is the decision of the court and the order of retention is granted. He said nothing further. He said nothing further. He said nothing further, and with respect to that, if this court will recall Cruz versus Vach, those kinds of findings have been held to be enough. Our position, frankly, is that this case, that David B.'s case, is identical to the circumstance that you were presented with in Cruz versus Vach, in which even the patient's physician testified that it was his belief that the individual should not get out right away, but only gradually. And in this case, that was the position of both the witnesses on behalf of David B.
The appellate division in your case said the evidence established, the appellate division at least tells us that the evidence established that indeed a mental illness is defined by 321C(I).
That's a bit, that I'll concede is a bit problematic, because that's not mentally ill. But I think what the appellate division was doing is, if the court were to read its case in Cruz versus Vach, you sort of did the same thing. You first discussed the definition of mental illness, citing that same statute, and I think that was for a very simple reason. I think the two things that have to be shown: mentally ill, that he indeed suffers from a mental illness, and that's the definition of mental illness, and then whatever dangerousness that it is you be shown. If there are no further questions, I would just ask first, of course, that our view now is, if no constitutional issue, the appeal really needs to be dismissed. But should the court decide to grant leave nunc pro tunc, which presumably is not unheard of, we would just ask that the case be...
Thank you. Ms. Aldea?
May it please the court, good afternoon.
Good afternoon.
I'd like to conclude for us by starting at the beginning, and that is whether the statute on its face requires dangerousness. And we would argue, in distinction to the arguments that have been made thus far and what this court has stated, that on its face, every single subsection of that statute has an element of dangerousness. In other words, by the appellate division finding specifically that subsection C1 was satisfied, it necessarily found that the defendant was dangerous as required by the Constitution, irrespective of its finding under C2 that the defendant did not rise to that level of dangerousness.
The statute doesn't use the word dangerousness, right?
No, Your Honor. However...
So my question is simply this. Has this court ever written in to that statute such a provision, such a component? Have we ever done that?
No, and my argument here is that it's not necessary for this court to write in anything. In fact, it's not required. What the lower courts have done in their analysis is they have read in an element of dangerousness, which is not necessary to do because the statute on its face contains it. And
isn't the citation to 330.21(c)(I) a little bit problematic?
No, Your Honor, it's not. And this is the reason for it. Dangerousness is not a term as far as the Due Process Clause is concerned. The Due Process Clause, which is the constitutional objection to the extent that one exists here, in this case at all, requires only a balancing. It doesn't require that a word, dangerousness, be defined in any particular way. It requires that a defendant's confinement be commensurate to the level of danger he poses. It requires that no more restrictive confinement than is absolutely necessary is imposed. And that's why the Supreme Court in Fuchsia focused, taken in context, on dangerousness. It didn't like the idea that a person can be held when they were either no longer mentally ill or no longer dangerousness because it was no longer commensurate. The punishment was no longer commensurate, or not the punishment, but the treatment.
Protection was their treatment.
The protection was no longer commensurate to the harm that it sought to avoid. Viewed in that sense, if we go to the beginning, the least restrictive standard is found in 1.0320 of the Mental Hygiene Law, the definitions. And that, by the way, is the standard that is contained in 330.21(c) subsection 1. Now, 1.0320 defines mental illness as an affliction with a mental disease or mental condition which is manifested by a disorder or disturbance in behavior, feeling, thinking, and this is the key, to such an extent that the person afflicted requires care, treatment, and rehabilitation. In other words, if treatment, care, and rehabilitation is not provided, then the person will become dangerous. Because without even putting in the word danger, the statute contemplates that there exists a possibility that a mental disorder can exist, that in fact a mental illness can exist, but that it does not rise to the level, to the extent of requiring treatment. Now, if we take that to the next level is 330.20 sub D, which defines mentally ill. This is what is required for confinement to a non-secure facility. The only distinction between subsection D and 1.0320 is that an additional element is required. In addition to mental illness, it's also required that inpatient service is necessary, is essential to the defendant's welfare, because the defendant's judgment is so impaired that he is unable to understand the need for such care and treatment. In other words, If we were to release the defendant, as would be authorized by 1.0320, then that defendant, not knowing that he needs treatment, would not pursue it. He would become dangerous if placed in a less restrictive environment.
Why do you say that? I mean, aren't there countless people walking around who are utterly harmless, who don't care for themselves, and who aren't aware of their condition? They're harmless. We had seen them in the streets of cities for quite a long time, hopefully not that much anymore, but they were there. They posed no threat of danger to anyone, possibly to themselves, but that's not a basis to confine them based on criminal statutes, is it?
Well, Your Honor,
we have to, what I understood Fucha and Jones to say is that there must be some element of dangerousness where they're going to hurt someone. So that's what the remand is going to be all about, if there is to be a remand. Do you quarrel with that?
Yes. Actually, Fucha and Jones also, as do the statutes, require define dangerousness as applying to danger to oneself as well as danger to others. And the distinction here is to say that there are plenty of people walking around harmless that have mental illnesses. I would agree, there are. But 1.0320 contemplates that. It requires, it defines mental illness not only as a mental disease, which would be that of a harmless person, but it incorporates an element of dangerousness by saying that this is manifested and is present to such an extent that the person afflicted requires care, treatment, and rehabilitation.
Ipso facto. So you say that the inability to care for oneself and to recognize that inability is ipso facto constitutionally adequate to live side by side with Fucha and Jones.
Yes, Your Honor.
That's your position?
That is essentially the position.
Okay. Now, that's not quite what the Attorney General is saying.
No, Your Honor, it's not exactly the same. Additionally, in terms of that, mentally ill, which is under Section 33020 sub D, imposes the additional requirement in order to confine someone in a non-secure facility, an additional requirement from 1.0320, and that is the inability to understand the need for such care and treatment. What essentially I'm arguing, it's not so much of, it is in a sense that dangerousness is ipso facto contained in this. But the reason for that is that dangerousness, as defined in a constitutional sense, as defined by the Due Process Clause, is not a definition of a word. It's not a term. Due process doesn't require dangerousness. What it requires is a balancing. And the reason that Fucha and Jones focused on that element of dangerousness is because in looking at the statute that they were analyzing, which is not identical to New York's statutory scheme, they found that it would be, in evaluating due process, if one of the elements wasn't there, then the level of confinement would surpass the need to protect the public. That's the underlying theme of due process. New York's statutory scheme is different because at every level it contains this principle of due process. It provides in 1.0320 that a person can be released, assuming that even though he has a mental illness, even though he requires care and treatment, because he recognizes the need for such care and treatment, presumably he'll seek it out. It contemplates that under 33020 subsection D, a person can be placed in a non-secure facility, even though taking him out of that facility would mean that his welfare would not be served.
What's the, if we were to remand, what would be telling the lower courts as far as what standard to apply? What do we tell the lower courts on a remand?
The problem with the remand would be that essentially you would be telling the lower courts to do what they did. You would be telling them to make a finding of whether the defendant under 33020 subsection D, whether the defendant has satisfied that requirement. And the lower courts have already done that in this case. In fact, I would just like to correct a point that was made in the defendant's brief in this case. This is on page 13 of the reply brief, and it's really an argument that is central to their theme. They claim that the lower court, the hearing court, never cited to subsection D, but in fact that's not correct. In its retention order, which is on page 14 of the record, the hearing court expressly cites to subsection D. So in this case, the finding that this court would be remanding, that the court would remand this case for the hearing court to make, has already been made and has already been cited to. So that is why we disagree, and we think that a remand is not appropriate in this case.
Thank you, Ms. Aldea. Ms. D'Elia?
President, just quickly to respond to the last point, so it's still fresh in everyone's mind. The language that counsel is referring to as boilerplate language in the standard retention order, it did not appear that subsection 1D didn't appear anywhere in the judge's actual analysis and in his decision. I concede it was in the boilerplate language of the retention order itself.
If he had made that finding, presume that he did, and that he had made that finding as to David B. and Richard S., is it over for you?
He would at that point have been importing the constitutional dangerousness that Mr. Kleinbart was speaking.
Because it's so odd to me. I mean, the appellate division cites C1 and C2, but then adds a sentence which seems to imply that they're flipping over to D, but they never cite it. I mean, I asked counsel just a few minutes ago about David B., and they cite to the definition of dangerous mental disorder. And they say, well, but in any event, they've established that he's mentally ill, but they don't cite to the statute. And I mean, if you had just taken that, wiped that citation out and just said mentally ill as defined by the statute, it's over. And I mean, you're here, and this is an important case to you, I know, and it's very significant in its ramifications, but it's very odd. It seems to me if I took Richard S. and I went to page 497 and I struck out at the very bottom, it says, the sentence reads as follows: contrary to the contention of Richard S., however, preponderance of evidence demonstrates that he still suffers from a mental illness. And guess what they cite? 330.21c1. If I just struck that out, it's over.
But, Your Honor, I think that the citation of 1C1 really was very, very meaningful in revealing the court's real misunderstanding here. And maybe if what the court's
I guess what you want
us
to do is to make it clear to them that if someone's mentally ill as defined by D,
yes,
that they can be retained and it's not a constitutional deprivation.
right.
Okay, and you want us to make it clear to them then that the definition in C is a separate matter.
Yes, Your Honor, as long as you're asking for our wish list, what I think what we're trying to get you to
It's just after
to
Christmas.
say here is that not all people who have disorders manifested by disorders, have illnesses manifested by disorders of thinking, judgment, feeling, or behavior necessarily are also dangerous. That there's got to be something more. There's got to
And
be
you say that
finding.
more evidence would be needed then?
There has to be something else, and that the 1D standard is just fine. That's constitutional. The 1C really reveals the court's understanding that all people who have mental illness are dangerous, and it becomes it's so confusing for the courts and the practitioners that yes, that would be part of our wish list.
Now, speaking of a wish list, can I ask you this, please, in connection, while we're talking about wish lists, this statute was written before Jones and Fuccia, right? So legislature didn't have the benefit of those findings by the United States Supreme Court that there should be elements of dangerousness involved, or however you want to denominate it. Would this benefit from a legislative review or a Law Revision Commission review while you're on the wish list, apart from what we do here, and we're going to do the best we can?
I think yes, Your Honor. I think that there's so much overlap in the language that we're expecting people to understand that mental illness doesn't mean the same thing as mentally ill, that dangerous for one facility doesn't mean dangerous for another facility. I'm not saying that the statute's unconstitutional. I'm saying it could be read constitutionally, but I'm also saying it's very confusing.
D'Elia,
Go ahead.
sorry, I interrupted your answer to Judge Graffio before, and I'm interested in that answer as well, as to the sequence of the hearings. If you were successful in
Yes, Your Honor,
having...
I do have that information for you. Oh, yes, I have it right here as well. In David B., the actual order expired on May 17th, and there's a new application before Supreme Court in Brooklyn before Judge Mason. In Richard S., the last order also has since expired in late October, and there's probably another hearing. It's just that he's no longer under our jurisdiction anymore, because when he was sent back to a non-secure facility, he was sent to the Canadian border up in the 4th Department. So I think there is something pending, but I really can't swear to it.
Can I ask you one last question? 33020, 330, no,
No.
33020C1, mental illness as defined in 103 sub 20 of the mental hygiene law. That standard is not a constitutional standard, are you saying?
Yeah, I'm saying that that's one prong of a constitutional standard, that's what mental illness is. And when we need to have a working definition of mental illness, and it's a pretty good one. But it doesn't address the dangerousness issue at all, and that's the second prong of the constitutional question. Your Honor, just to finish my answer to your question,
Certainly.
the answer would be that since they both expired, since the filing of the appeal, we certainly have no problem with the court issuing a prospective ruling, except to the extent that if the court finds in Richard S. that a mental illness in remission is not in fact a finding of mental illness, that in that instance that it would have to be a reversal. Thank you, Your Honor.
Thank you.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence, and appear here next Tuesday afternoon at 2 p.m., at which time this Court now stands adjourned.
Good day. Thank you.